number 19, Bill Birds versus Stein Law Firm. Counsel?
Thank you, Your Honor. May I reserve 2 minutes for rebuttal?
Of course you may.
Thank you. My name is Thomas Torto, and I represent the plaintiffs' appellants. May it please the Court. I'd like to address 3 points. The first point is on the pleading aspect of this case. Contrary to the appellate division's decision, it's our position that the complaint, as amplified by the plaintiff's opposition papers to the motion for summary judgment, set forth sufficient facts that state a cause of action under Section 487 of the judiciary law.
Well, should we be reviewing this under a motion to dismiss standard or a summary judgment standard?
Summary judgment. Summary judgment.
Okay.
So any deficiency in the complaint was cured by the plaintiff's opposition papers, particularly the affirmation of Harold Furlow, the plaintiff's expert.
Was Mr. Furlow counsel?
No, he's solely an expert.
Who was counsel?
Michael Polinsky.
Thank you.
Is the attorney of record, or is counsel on the motion. And the core position is that the defendant attorney deceived the plaintiffs into filing a meritless lawsuit in an improper forum motivated solely to collect a large legal fee.
So your allegation under the statute is based on what happened, misrepresentations, you allege they're misrepresentations or deceitful conduct before the action was commenced, right? You're not relying as part of your cause of action on what happened after the action was dismissed. Am I correct about that?
We're relying on the misrepresentations committed before the action was commenced, and it's our position that under Amalfitano, once the lawsuit was commenced and prosecuted and the client continued to be billed, that the deceit continued.
I'm sorry. One quick thing. If we conclude that loof is still good law,
Yes.
do you lose?
Well, it depends on which loof we're talking about.
I'm talking about Court of Appeals loof.
Yeah, yes, if you conclude that the Court of Appeals decision in loof in 1884 is still good law,
Right.
I think we lose.
Okay.
So why is that?
Well, that was actually my question.
Well, because in Amalfitano, the 2009 decision, this court cited the decision of the general term of the Second Department rendered in 1874 for the proposition that a lawyer who galls a client into bringing a meritless or unnecessary lawsuit violates Section 487.
But there's a difference between what happened here, right? I mean, in that case, the suit itself is not deceitful. You just didn't need to bring it, which is different, I thought, from your argument. I thought the argument here was that the suit was absolutely, obviously, on its face, frivolous to begin with.
Yes, and I think that's the same as the loof in 1874.
Is it possible to reconcile loof with the actions in this lawsuit? And specifically, I look to the fact that wasn't this case dismissed in federal court, but the client wasn't notified for a number of months, and almost to the point where the time ran out and dealing with it. And wouldn't that be an action against the party, which is what loof requires? You see what I'm saying?
Against a lawyer?
Yes.
Yes, I think that.
So it would be possible to both characterize loof as good law and at the same time say that there was an action by the attorney here, there was an action against the party in the context of a lawsuit that would reconcile a potential deceit here with loof and save this.
Right. But it seems, though, that just a matter of logic and common sense, that a lawyer who deceives a client into filing a meritless lawsuit and continues with this meritless lawsuit solely to generate a fee, that's covered by the statute. Because once he starts a lawsuit, the deceit continues. It's ongoing. You know, it's not like these other cases where the deceit had nothing to do with a lawsuit. I mean, the object of the statute is to make sure that lawyers are honest before the court and enhance the truth-seeking function. And in a case like this, where a lawyer brings a lawsuit that's, the claim is that it's totally improper, totally without merit, in an improper form, to add insult to injury, and the lawsuit's presented in the court, it seems that the statute
But
covered that.
I thought the claim went one step further, and you can correct me if I've misunderstood the cause of action here. I thought the claim was not just that the attorney brought a frivolous lawsuit, which could be incompetence, right? But not deceit in the
Could be.
sense of I knew I was doing that. I thought the argument being made was that, and I thought that's what you were repeating now, that the lawyer knew it was frivolous, brought it anyway, persuaded the client to proceed with this lawsuit to get the money from the client, and then, as Judge Fazer already pointed out, done other things post-filing that appeared to be deceit, if not on the court, on the party.
Yes, I agree. I think that's part of the entire claim. It's all part of a package. And I would note, in the defendant's papers, the defendant attorney signed an affidavit, it's at pages 58 and 59 of the Record on Appeal, where he says that the plaintiff had no case. And to begin with. So why was this, that begs the question, why was this case even brought in the first place? The agreement provided that you couldn't sue General Motors, you couldn't challenge the license, and if you did bring it, you had to bring it in the state of Michigan.
So your argument is the catch-22 argument, which is that I go to a lawyer, he says, yes, you've got this lawsuit, you bring the case, you pay him the money to bring the suit. There's no guarantees according to everything. And then when he's sued for legal malpractice, he says, well, he never had a case to begin with, so there's no chance of you winning, therefore there's no loss, there's no legal malpractice.
Correct.
Yeah.
That's an argument. And we think that under Malfitano, again, I'm relying on the second department or general, whatever it is, the general terms.
Yeah, but you got to listen to
decision.
Judge Stein's question. Judge Stein's question was, how do you win under Loof, not under Malfitano?
Well, I agree, but I don't think Loof is good law because it wasn't cited in Malfitano. That's what.
Sir, isn't there a difference in Loof? Because in Loof, the case itself is not frivolous. Where's the deceit on the court? There's nothing frivolous about the action.
I thought it
The
was.
deceit is in advance, telling someone you need to do this to achieve these goals.
But that was false. It was unnecessary. The lawsuit was unnecessary. In other words,
Unnecessary, but not frivolous.
I think it was frivolous too, Your Honor.
There's nothing frivolous in the partition. You could proceed with the partition.
Could, but it was unnecessary. That was the point.
all right.
And then on damages, we rely on Malfitano, that the lawsuit, that the attorney's fees are a recoverable item of damages. And also, again, in Malfitano, this language, quote, the lawsuit could not have gone forward in the absence of the material misrepresentation. That's this case. This lawsuit, the underlying lawsuit, never would have gone forward.
Here it was based, I'm sorry, in Amalfitano, it was based on misrepresentations in the complaint itself. And but for those misrepresentations in the complaint itself, you would have no lawsuit. That's a little bit different than misrepresentations, it seems to me, to the clients saying, yeah, I think you got a lawsuit, and and here we'll bring the
Well,
lawsuit.
it's even more than that. Just
What
I
were the
think-
misrepresentations in the context of the lawsuit itself, to the court, to the parties?
Just bringing the lawsuit. And the lawsuit had no merit as a matter of law.
So anytime a lawyer brings a lawsuit that they think may have no merit, but they bring it anyway, then that states a claim under this statute, in your view?
No. Anytime a lawyer brings a claim that he knows has no merit, and he's doing it just to generate a large legal fee, and taking advantage of a client who doesn't know the law and relies on a lawyer's advice, that was subject to the statute.
Well,
That's
what
we
if
say happened here.
the client says, I just want to sue this person, even if it's just to put them through the aggravation of having to go get a lawyer to get my case dismissed.
Well,
I mean, there
think
may
that
be
would
other ethical problems with a lawyer who does that, but is that covered by this?
I don't think so. I mean, assuming the lawyer tells the client you have no case and don't bring it, the client says, I want to bring it anyway, I don't think the client's not deceived. But where the lawyer tells the client, remember, this is a blue-collar guy, goes to a lawyer, asks for advice on a complicated trademark question.
Well, you say it's a blue-collar guy, but who's also dealing with his brother, who's an attorney,
Well, you saw
and
the
who is sophisticated enough to understand this business of having to deal with the licenses with GM.
Right, but, this guy spelled copyright, W-R-I-T-E. I mean, I don't think they're all that sophisticated, Your Honor.
Well, that brings me to a totally minor detail. So is it Bill, apostrophe S, Birds, or is it Bill Birds?
The way it is in the
That seems to
caption.
be changing throughout the record.
Bill Bird's, common, INC. There should be no apostrophe.
Thank you,
And I'll
counsel.
reserve, thank you.
Counsel?
May it please the court, James Spithijanis for the defendants. Amalfitano is a different case than the case here. The certified questions before this court were whether unsuccessful deceits are actionable and whether a proximate cause of an unsuccessful deceit can be the legal fees that a defendant pays in connection with a lawsuit that was premised on misrepresentations.
Well, you are correct, because he is claiming the deceit was successful, so you're correct about that in terms of the attempt. But could you perhaps address what I was asking counsel about with respect to perhaps a distinction between Loof and what he's arguing?
I don't think there's a distinction between Court of Appeal. I think there is a. I don't think there's a distinction between Loof on the issue of deceit and the Court of Appeals' opinion that the deceit has to be in connection with a pending litigation against a party and cause injury to a party. I think Loof was absolutely correct. Amalfitano did not disturb Court of Appeals Loof. It cited the appellate term Loof for basically the point that Judiciary Law 47, or what was the statute at that time, is not just the codification of fraud, and deceits don't necessarily have to be successful.
Let me ask you about Melcher then, because as I read Melcher, it says that the cause of action is a common law cause of action. The statute doesn't have in it a cause of action, it simply has a penalty enhancement. Is that a way to distinguish Loof?
I don't think so. I think that it is statutory. It derives from criminal statute.
How do you read Melcher? Do you read Melcher differently than I do?
I think so.
So tell me how you explain that language in Melcher.
Can you please provide that again, Your Honor?
Sure. It says, a cause of action for attorney deceit therefore existed as part of New York's common law before the first New York statute governing attorney deceit was enacted in 1787. The 1787 statute enhanced the penalties for attorney deceit by adding an award for treble damages, but did not create the cause of action.
Well, I think that just because in Melcher the court stated that that Judiciary Law 47 derived from common law doesn't mean that the law following it is not good law. I believe that in this case that you always have to prove an intent to deceive the court or a party to a litigation in a pending litigation, and treble damages will result if there's proximate cause. So I'm not sure that the distinction that's made in Melcher carries the day in this case for the appellant.
Well, he says, they argue that there was deceit post the filing.
Yeah.
Why wasn't the conduct that they're referring to the kind of deceit that's covered by the statute?
So I'd like to comment on that, and to Judge Fahey's point in the earlier argument. The allegation is that Mr. Stein hid the memorandum in order dismissing the underlying case for lack of jurisdiction. So, obviously we deny that. However, the case was already over at that time. It wasn't a pending lawsuit. It was a dismissed lawsuit.
it's an action towards a party. The dismissal was, as I understand, you know the record probably better, but the way I understand it, the dismissal occurred in March 31st of 2008, and it's a question of fact as to whether by late 2008 the plaintiff was informed. That certainly involves an action of the court and an action of the party, and a possible deceit as to informing them.
I think there is an argument that it may be considered an action toward a party. In plaintiff's reply brief, they state that the actions post-dismissal of the complaint are not the basis for plaintiff's lawsuit. That's on page 16 of their reply brief. Also, there's a proximate cause problem. What would happen next if, as we point out, there's still...
Well, tell me what the proximate cause problem is.
The proximate cause problem is that suing General Motors in Michigan, it seems like in the memorandum of order, there was an instruction or at least advice from the court in some way, if you want to pursue this litigation,
Right,
it
you
has
can't
to be
do it in New York,
Michigan.
but you might be able to do it in Michigan, right?
Right. So if the action is brought in Michigan, the plaintiff, as a legal malpractice plaintiff, has to prove, in this case, that he would have prevailed in that litigation.
That goes back to the legal malpractice problem, but it doesn't go to the deceit problem. I think you got to distinguish between the two here. Legal malpractice, I see what you're saying there, that they couldn't be successful no matter what, so they don't have a cause for negligence. That's not the same as deceit, though. The argument is that you would hide the deceit because this is the argument. I'm not judging the argument, but the argument would be you were hiding the deceit because that way it would be easier for you to keep the money that you were given to bring the action. I understand the argument. The real question is whether or not that's an action in the context of litigation towards a party.
Yeah. I think arguably it can be, but in this case, there's no proximate cause. There was no additional legal
Well, the
fee.
proximate cause is a pure negligence question. I'm having a difficult time to see how it applies, but I understand your argument.
But there must be proximately caused injury to a party to prevail on a judiciary law 487 claim.
Right, thank you.
Counsel, does the 487 claim need to be pleaded with particularity?
It does, and the
And
lower
what-
courts have applied it, applied 3016B that way. In the second department, I think what the second department was grappling with was that there were only 3 causes of action in this original complaint. It was a pretty standard legal malpractice case with a duplicative cause of action for breach of contract and another duplicative cause of action for fraud. The only time Judiciary Law 47 appears is in the last paragraph of that complaint. I guess the plaintiff figured he'd throw in Judiciary Law to potentially get treble damages, but it's the exact same claim as the fraud claim. And I think the second department was correct, even though it was up on an order granting in part a summary judgment motion. I think they were correct in stating that the complaint does not allege an intent to deceive in a litigation, and that the intent to deceive was directed at the court or a party. There are allegations in the fraud cause of action that state that upon information and belief, Mr. Stein knew or should have known that this case wasn't going to work out, but that is far from pleading a Judiciary Law 47 claim.
So you're saying if the complaint had asserted some action post the filing that suggested fraud or met some minimal threshold of the detail of suggesting fraud, that would have been good enough?
I think it would have been good enough if that allegation was made and there were specific allegations as to Mr. Stein's alleged intent to deceive
Let me ask you
a
this.
party or the court.
I know the appellate division said that 3016B didn't apply, but let me ask you, did you ever make any motion to dismiss on this, that these pleadings were dismissible?
We did not make a motion to dismiss.
And you never made any 3211A7 motion either, did you?
I don't believe so, Judge.
So we're really not in the motion to dismiss failures to plead with particularity bailiwick. We're really in a 3212 summary judgment posture, correct?
Correct.
Right. So how does particularity even apply then?
Well, I think it applies.
Because we're not talking about how you pled the pleadings. You didn't argue that. You never raised that. You didn't preserve that.
What the Supreme Court did in deciding our motion for summary judgment was it granted our motion on proximate cause grounds with respect to the legal malpractice cause of action and held that the breach of contract and fraud causes of action were duplicative. There were only 3. Then...
No, I understand that, but in order for you to argue before us today that this action was not pled with sufficient particularity and that 3016B would apply, which the appellate division did, and whether or not that's error is something we have to decide, but you had to raise that issue in a motion to dismiss because it goes to the face of the pleadings themselves. And I don't believe that, I could be wrong on the record, I'll go back and look, but I didn't think that's what was done here. I thought that was never done, that this was a pure summary judgment motion. Therefore, it's, balancing the facts, the normal kind of thing.
Right. I don't believe that was done, but what the second department did, in our view, was correct.
I agree with you. They did raise it. I agree with you. I understand what you're saying. I'm saying they might be wrong, but I understand what you're saying.
And in this case, may I have one moment?
Of course.
There has to be an intent to deceive, and I think Mr. Polinsky's actions, the plaintiff, show that he was not deceived. He was boiling mad. He was angry at GM that they were taking advantage of him by having him sign these licensing agreements. There were infringers in the business who were making fake items as opposed to Mr. Polinsky's genuine items, and they were getting away with it. He was angry. He wanted to bring a lawsuit. He wanted to bring his allegations before the judge. I think his deposition testimony sums it up when he said, I see this as a win-win situation. If I lose, then they have a right to chase my infringers out of the industry, and I win. If I recover, then I win as well. So I said, okay, who do I make the check out to? He wanted to bring this lawsuit. The lawsuit was unsuccessful, but lawsuits are sometimes unsuccessful. Thank you.
Thank you, sir. Counsel?
Just briefly, Your Honor, with regard to the defendant's position that Mr. Polinsky wanted to bring this lawsuit and it was a win-win situation, it's our position that that raises a question of fact, and that given the advice that he was given, that, yeah, he might say that, I'm going to win either way, even if I lose, I'm going to win. We don't think that defeats this cause of action as a matter of law. Secondly, with regard to the particulars of the fraud, the complaint is inartfully drafted. However, that deficiency was cured with the opposition papers, and like Judge Fahey said, this is a summary judgment motion. The court considers all the papers. It appears that the appellate division only considered the complaint, and that's apparent from them citing, from that court citing CPR 3016B. But this is not a pleading motion.
So to be clear, what are the post-filing deceitful actions by the lawyer
Concealing
that are in this record?
Concealing the adverse decision and not telling the client about it. And that in and of itself could sustain a cause of action.
And then how did that particular conduct approximately cause any damage to the...
According to Mr. Polinsky's affidavit, he was, by the time we found out about it, the statute of limitations had expired.
Right, but we know that he wouldn't have had a cause of action anyway, right?
Right.
So how did that... I mean, I thought that the damages that he was really alleging by this whole thing had to do with the legal fees that he
Correct.
paid, but he'd already paid those.
Yes.
So
I think he'd get the fees back. And there's law to the effect that a lawyer who, acts inappropriately to our client forfeits his fee. And then that principle would apply here. But it just seems to me, though, that getting back to that Malfitano argument, where the court quotes the Second Department's decision, quote, in Loof, the plaintiffs accused their attorney of gulling them into bringing an unnecessary lawsuit motivated solely by his desire to collect a large fee to represent them. That's this case. And you can't get around it. The court gave its imprimatur or its endorsement to a cause of action under those facts, under Section 47 of the judiciary law. I mean, you just substitute the parties in this case with the language in Amalfitano. You know, the plaintiffs accused the defendant of gulling him into bringing an unnecessary lawsuit, whether it's meritless or unnecessary, it's the same. They shouldn't have brought the lawsuit, never should have been brought. And, you know, and the lawyer should have told the client, you got no case, and, you know, and not collected a large fee. So, thank you. I'll rest of my brief.
Thank you, counsel.